Good evening. This is Rahul Reddy. We're live here from Houston, Texas. Every Tuesday from 5 p.m. to 6 p.m. Central Time, we do bring in immigration updates. Emily, what do you have today?
We're going to start talking about the H-1B lottery process. So this year's H-1Bs will become available on October 1st, 2025, but that process actually starts next month with the lottery and registration. So we'll talk about what those steps involved and what you should be doing at this point to make sure you're ready to go. We also want to talk about checking your I-94 online through the CBP website. When should you do it? When is it supposed to be updated? When does it not get updated? And what to do if you notice a problem with it. And then we've been talking quite a bit on here about avoiding travel. And a lot of people are questioning whether that's really necessary. Do we really need to be that fearful? So we'll talk about why we think that you do need to avoid travel in certain situations. And lastly, H-1B employees are coming under additional scrutiny through the FDNS, Fraud Detection National Security Directorate site visits. Why are we seeing more of these happening, and what you should prepare for, what to do in the event of a site visit?
Emily, as the fiscal year 2026 starts in the March, where the companies have to register, they have to first enroll in the online account system portal created by the USCIS. Then they have to register the employees in there, and they have to pay the fees of, now the fees has increased. Previously it was $10, it's $215 right now. And the selection process, I think so, is getting over on March 24th, is it right, Emily? That's the last day to file the application. We strongly recommend companies to register as early as possible, not wait until the last moment. And also, there is no advantage in people filing with multiple companies, except that they can choose the companies, but it will not be that they're going to be offered in 2 times. So it's not like if Rahul Reddy with the date of birth XXX is going to be only one person if either he applies for 2 or 3 companies. So there is no tactical advantage in filing with multiple companies, which, there are some people who abuse when there's no jobs also they file. But right now, I don't think so anybody's going to do it. Anybody should do it. And it's no advantage anybody to do it unless they have a real pressing job with 2 companies, then it probably may be okay. But I still want people to check with the lawyer if that is okay to screen independently before filing with multiple companies. Emily, in the lottery system, what are the precautions people should be careful about?
Yeah, so at this point, employers should already have their MyUSCIS account created, a registrant account. The employee does not create an account in MyUSCIS for this process. You do have the option of having a MyUSCIS account, but it has nothing to do with the H-1B lottery process. You won't use it for any part of this process. At this point, you should be making sure you have your passport, it's not expired. If you have a U.S. master's degree, making sure you have your transcript and degree certificate for that. If you are graduating in May with a master's degree, you can still potentially be registered under the master's cap, as long as once you're selected, you wait until you've graduated before filing the petition, because you have until June 30th to do that. So starting March 7th, employers and their attorneys can enter information into the MyUSCIS account system. All we enter is the employee name, passport number, date of birth, country of citizenship, and then whether we're filing under the master's cap or not. Then the rest of the information is company information, very basic that's needed there. The employer and the attorney will coordinate to get that registration verified by the company and approved to submit, and then we pay the fee electronically for that $215. All of that has to be done between March 7th and March 24th. Now, personally, I won't be doing mine on March 7th. I like to wait a couple of days because there's always a glitch during the first couple of days of the process, and I wait until the glitch gets taken care of, and then I start submitting mine. But I definitely don't recommend waiting until the very last day, because you only have until noon Eastern time. So if you're at 11:59 a.m. Central time, you're going to be too late. So you have to be aware of that. So don't wait till the last day to get it done. Make sure your employer is on top of that. Make sure they can log into their MyUSCIS account now. You don't want to wait until the last minute on that. The lottery will close March 24th. Around March 31st, we start typically seeing selection notices, usually without any kind of announcement made by USCIS. We just start getting emails. Sometimes we don't even get emails. We just have to log into the MyUSCIS account and we randomly see selection notices. We then will inform employers of who's been selected. Those selection notices usually come in over the weekend. They start on a Thursday, continue maybe through Friday, Saturday. And then usually by Monday, it's over. And then a couple days later, they actually make the announcement that they received enough and did the selection process and it's all done. Then we have from April 1st to June 30th to actually file the H-1B petition. This is where more of your documents come into play. You need to have your copy of your passport, your visa stamp, your I-94, your education documents, degree certificate and transcript, possibly an education evaluation if your degree is not from a U.S. school. The company needs to fill out the I-129 form, make sure they obtain a certified LCA, labor condition application, verify that the salary being offered meets the prevailing wage, place a notice of filing at the company location, the work site where you're actually going to be working. All of that has to be done before the petition can actually be filed. And then once it is filed, USCIS will issue receipt notices and we'll start adjudicating them sometime between June and October. This year, the cap gap, the automatic cap gap, which is for people whose OPT is expiring before October 1st. If your H-1B is selected in the lottery, you file the H-1B before your OPT expires, requesting a change of status, then you're authorized to have your cap gap extended, your OPT automatically extended due to the gap caused by the cap. And this year, the cap gap goes all the way till April 1st of next year. So if you don't get your H-1B approved by October 1st, this time around, it's not as big of a problem. Your cap gap continues all the way till April 1st to allow that H-1B change of status to be approved.
And with moving on to Emily, isn't it an advantage if people file in the lottery system on March 7th as compared to the last day, Emily? Or everybody?
No, everybody gets the same chance of selection regardless of when you submit, as long as it's during the window, and regardless of how many companies submit your name in the lottery. You only get one chance no matter what. And so when your name is submitted does not matter.
With regards to the I-9 for checking, and we see a lot of people are going out of status or probably becoming unlawful if their I-94 expires. This is the most common mistake. As you know, that passport, typically most of the countries will issue passport only for 10 years. Here is the problem that comes in. Let's say, for example, if your passport is expiring in 2025 September, and when you go for the visa stamping, they will give stamping until the time the H-1B expires or H-4 expires. So in this case, let's say in 2027. So just because your passport is expiring when you're entering into the country, the CBP may only, most of the time will only give based on the passport expiration, and then people will become illegal even though they have an I-7. They may become illegal. Even though they're 797, which is approval of the H-1B or H-4, or if their passport visa is still valid until 2027. Once the I-94 crosses, you are in the country, you may get into trouble. We want everybody who comes into the United States to check the I-94 if the validity is proper. There are also situations where if you're working for company A, which passport stamping is expiring in, let's say, September 2025, and you now move to company B and you have not got the stamping with company B, and you have now traveled outside the country and come back in. Sometimes, and we see that mistake when you don't show the H-1B approval of company B, they may only give until September 2025, not based on the new H-1B approval. And that becomes a problem because then you may become unlawful present in the country. Then I-94 is restricting wrongly, which need to be taken care. If you check the I-94 online, and believe me, there are, and that too before the I-94 expires, there are plenty of ways and easy ways to correct it. But if you let the I-94 pass away, then it will become a major problem. There is only one exception to it, which we know about, is if you have an advance parole, which is valid for 5 years, and you're entering into the country, they may only give a permit to stay for 1 year. In this period of time, only this period of time, only this point of time, you may ignore that 1 year. You can stay here on the adjustment of status EAD, not a problem at all. But for 95% of the people, they have to make I-94 very seriously. Even for the people who are coming on a visiting visa, 6 months is not guaranteed. Sometimes they may only give for 1 month. They may only give for 2 months. Those people who are coming in H4, H-1B, L1, L2, everybody needs to go to CBP's website and check to see if that is reflecting properly. There are many ways to correct it if it's been detected before. And the ways to correct if the I-94 passes are very difficult. We have explained previously, but we want all of you guys to check the I-94 properly.
Yeah, every single time you enter the US, you need to go and check your online I-94. Make sure that it is even there, that you can access it. Sometimes it doesn't show up in the system. Make sure that the date of admission is correct. Make sure the visa category is correct. A lot of times I see people who are coming in on an L mistakenly be entered on a B because they also have a B visa in their passport. Well, a B visa, it does not authorize you to work, and it expires, that your stay is only going to expire in 6 months or maybe even 3 months, maybe 1 month instead of the 2 or 3 years that your L1 might be valid for. The other thing to be aware of is once you come into the US, you've printed out your I-94, and then you file an extension or a change of status with USCIS, at that point, once you get that extension or change of status approved, you'll get a new document called an I-797 approval notice. That document will have a new I-94 attached at the bottom of it. That becomes your new I-94. You do not need to check it online because the online I-94 is only issued when you travel into the country. USCIS also issues I-94 on approval notices. So if you're getting your approval notice, you won't see it reflect online. That's okay. But the next time you travel, you then again go online to get your new I-94. You don't rely on the one that's on your approval notice at that point. So anything approved by USCIS where they give a new I-94, it will not reflect online. Every time you travel, it will reflect online, and that's what you need to check every time you come into the US. Speaking of traveling, you've said many times that you can answer the question of, can I travel in 12 words? And it is no, 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 12 times. Some people say maybe we're being too fearful, too conservative. Do we really need to avoid travel? Is it that big of a problem? What do you say to that?
Absolutely, I was right and everybody else is wrong. Have no doubt in it. Every single day, so many 221Gs. I mean, people who have visa got approved and then they get the 221G. The online system says, oops, it's not, it's a 221G. We get so many consultations in it. And also, as we noticed that those people who have gone on, if the visa stamping was expiring 4 years ago, they were eligible for the drop box. And they all traveled to India to get the stamping. Right now, what happened to them? Hey, your stamping has expired more than 1 year ago. You do not fit into the regular drop box, so you have to come for the interview. That's going to create a lot of problem. It's going to delay the entire process, and I don't know whether you're going to have a job or not. Definitely not travel this 4 years. The biggest problem we face in this 4 years is that travel. Now, yes, we have seen administrations. I've been seeing so many different administrations. As an immigration lawyer, I've seen President Clinton, and then we have a President Bush, President Obama, then Trump, then Biden and then Trump again, and in which I've seen Clinton for 8 years, Bush for 8 years, Obama for 8 years, and so many people have seen this is the toughest time. And of course, we have seen the first Trump era that was difficult, very difficult, but it was not impossible at that point of time. I mean, we have had a lot of extensions denied, change of status denied, and we got it approved later on. They went for stamping. But right now, Emily, it is a complete different atmosphere in the consulate. Now, previously, when they were denying, especially for H1s and H4s, they probably have to get an approval of a different officer to go through those things to get the denial. Now, I feel that if they want to approve the case, they have to get the supervisor approve every visa, which is a working visa. That's how the situation is in the consulates right now. They don't want it. We don't know if they have some system in there where if a person does not, if the person may be rewarded for rejecting the H1, the working visas and the dependent visas, and probably getting demoted if they issue the visas. That's how I think the officers are behaving. And those people who desperately need to travel for any emergency reasons, I want you guys to evaluate yourself, get a lawyer, evaluate everything, and probably if you have a house, if you have a car, give up a power of attorney to somebody else to sell it, because you don't want to get stuck there and not come here. What are the alternative? Think about it. If you're going to get stuck there, what are the alternative things? We have had odd 485 denials recently, odd 221Gs, odd interpretation of DUIs, odd interpretation of the consultancies right now. There were FDNS inquiries where people have not responded to them, and now you are going to the consulate. That is a societal mission too. So definitely, I'm sticking with that. It's not 12 words, Emily. It is 13 words. It still is no, 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 no. All 13 words.
All right. Yeah, definitely. I think a lot of people think that even if under these new Dropbox rules, they still qualify for Dropbox, it's safe to go for stamping. But the same people who were qualified for Dropbox under the old rules thought it was safe to go for stamping as well. And the government changed the rules after they were already out of the US, and their Dropbox appointments were canceled. They were given 221Gs, told you have to make an appointment for an interview. Interview slots are hard to come by now, and so they're just stuck there. So if it happened once, it can happen again. Absolutely. They can eliminate Dropbox altogether. They can require interviews for everything. They can issue 221Gs, just delay long enough to where you end up losing the job and have no way to come back into the US. That's a huge risk to take. So if you're going to travel, you really need to think about, is the reason for my travel worth this big of a risk? And if the answer is no, then you really should avoid that travel. Now, what about advanced parole or people that have a valid visa? Are they safe to travel? Are they 100% safe to travel, or should they also be careful?
In general, especially the advanced parole, Emily, I have not seen any difficulty. Even though I've seen some of the other lawyers advising people not to travel, I've had a lot of people travel on advanced parole, no problem, none whatsoever at all to anybody at this point of time. And there are secondary inspections to a good number of people on the advanced parole. That used to be there in Biden administration, and that used to be there in previous administration, Obama administration too, because some of the airports, the officers are not equipped to handle the advanced parole. However, we have not seen any denials of entry on the advanced paroles unless, if somebody has a very major criminal record. I'm not speaking about these, typical people who might have some traffic tickets at the most, have no difficulties at all in advanced parole. Now, coming to the point of student visa, though, Emily, I want people to be very careful, though. I have had a good number of people getting denied entry, particularly from Abu Dhabi Airport and also from Chicago Airport. Very risky, these things. And I had some instances in Boston Airport recently. If there is any ambiguity of the jobs, though, and if there is any miscommunication of the jobs, though, had very much difficulty. I have some very top university people had some issue, either they have been working or had some issues on the resume or anything like that. They had big problems and they were being not allowed to come into the United States. Even some people where they were unable to produce the pay stubs, Emily, the person didn't have access to immediately for the pay stubs, especially in the Abu Dhabi airport. Oh, you don't have the pay stub, I'm going to deny the entry. Even for the student visa people, the OPT people who can work as a intern, unpaid internship, also had some difficulties. So definitely, if you're on student visa, if you want to travel, I would still recommend take a bit of caution before you travel outside the country.
All right. How about this FDNS? Why are we expecting more site visits? What is FDNS? What changed in the regulations recently that is impacting FDNS?
FDNS was created at the time, I believe it's Trump era that was created, FDNS, or maybe Obama, I forgot it. But anyway, FDNS was a voluntary system. That means that it's up to the employee to participate in the system. Now, they have put that in the regulations. Most of the lawyers have said that FDNS was completely illegal because it doesn't come under the law, it doesn't come under the regulation. However, the FDNS was the regulations were been issued on which went into effect on January 18th of 2025, which made it mandatory for the employers and employees to cooperate with the FDNS. And if they don't, though, their H-1B will be denied or revoked. So we have seen an increased scrutiny to a level where for the small consulting companies, not implementation partners, but consulting companies, they said it is probably mandatory for FDNS to inspect the things to getting the approval. Recently, I wrote an article on this in RN Law Group blog. If you want to study, I've given typically what kind of questions they're raising in the FDNS. And one thing that I noticed, a problematic thing, Emily, is that a percentage as a salary. Let's say, for example, Emily, I'm an employee of Reddy Neumann Brown, and let's say, for example, Reddy Neumann Brown has a contract with, let's say, Coca-Cola company. And if Reddy Neumann Brown is getting $100 per hour, and there is an agreement between me and Reddy Neumann Brown that I should be getting $80, it may be completely illegal because here the employer is more like acting like an agent, not like a fully controlled employer. There might be some issues with regard to the employer-employee relationship. The premise is that if the Coca-Cola company pays the company, then only you get the payment itself is completely illegal. It should be completely independent, even if the Coca-Cola company pays or does not pay. How much ever pays, your salary is according to the LCA, they're supposed to pay that salary. Nothing to do with it. And I've noticed that is a major problem in people in the FDNS visit, and also at the time when people are trying to enter into the United States in Abu Dhabi airport, in Chicago airport, that was being presented that I have an agreement with my company that they have to pay me 75% or say whatever the percentage it is, and they have been deported. And right now I've seen some of the H-1Bs getting revoked. Everybody who are listening, please visit our RN Law Group in the blog. I've written a good article on this FDNS visit. What are the questions that they are going to ask? What are the things that you need to be prepared of? What are the things that the employer need to be prepared of? And if there is any doubts, that it's better that you clarify it with your employer and probably your employer's lawyer. So it will be easier rather than clarifying it with the USCIS FDNS officer, which is not a good idea.
All right, shall we go to questions?
Emily, what about this EB-5? Now, have you heard the news that Trump is coming up with $5 million golden green card? I don't know. So here is the thing, people that have, like so many people, is EB-5 ending? Well, that requires a Congress approval. This is just a statement made by the president. Maybe he can propose it to the Congress, which I'm not sure that they're willing to act on it immediately on his thing. But it is not a reality as of now. It is just a mere statement. Remember that one time he said everybody who's going to be graduating from, including the community colleges, that they should attach a green card. That's a statement which Trump has given. Sometimes these statements will come out, but they may not have any truth in it. This one, at this point of time, I rule that it does not have any truth in it. It needs to go through the Congress, which the parliament is called Congress in United States. So that, which is very, it may be 6 months, 8 months down the line. Very unlikely at this point of time for the Democrats to support it. But we'll update it. But right now, the EB-5 is not going anywhere. There is no golden green card right now. Even though Trump made a statement, it doesn't become active item. You guys need to understand what he made a statement at the COVID. What was that? To inject Lysol for treating COVID. So yes, there are statements that come out from this president, but you have to take with a pinch of salt, guys. It's you can't just take it as what he says.
All right. Anubhav says, if the H4 EAD standalone got approved 4 days ago, does it mean that H4 will also soon be approved? Both were not filed together. So if you're seeing that it was approved based on the online case status, most of the time the H4 was also approved and not updated in the online case status. So you'll just have to wait and see what comes in the mail, but it's very likely that both the H4 and EAD will come in the mail.
How long it's taking for an advanced parole? This question is coming from Clavy26. Anywhere between 2 months to up to 2 years is the time it's taking for advanced parole. Then comes a question from I Love Trump from YouTube. He or she has a 5 years advanced parole. Can he travel multiple times at an advanced parole? The answer is yes. You can travel multiple times on an advanced parole, but please make a copy of the advanced parole and keep it with you. We have noticed that, especially if it's a paper advance parole, when you're traveling, the USCIS sometimes may want to keep a copy of it. And if you don't provide them the copy of it, they don't have a copy machine there. They might just keep the original. And if you keep the original, then you may not be able to travel. So just give a copy to them. Hey, you want it? Here's a copy of it. Take it. That would be better for you too, and no problems in traveling multiple times on a 5-year advance parole.
DM Fly says, my wife just got a change of status from H4 and H4 EAD approved. The H4 approval notice is good from February 2025 to July 2027, but for some reason the EAD is only valid in 2027 and for only 10 days. So it seems like the wrong start date is on the EAD, even though the end date is correct. What are my next steps? And should I continue to work now? Definitely have to reach out to USCIS. I'm assuming this was not filed along with an H-1B and premium processing. So you're looking at customer service. I've had decent luck lately with the live agent chat on the USCIS website. You have to go to Emma, and then there'll be a place to select chat with live agent. And then the last time I did it, I was number 99 in line, and it took about an hour before I was able to get chatted with, but I did get the information I needed. On the other case, I had this exact same situation. It was a premium processing case. They gave me an address of where to mail the EAD card to with an explanation. And then we're still waiting to get the corrected card back. So it's going to take some time. And your employer, her employer, if she is no longer in H-1B status and they're asking for her EAD card to complete the I-9 process, she won't be able to, I mean, she can provide it, but that start date, the employer may not accept it. So she may have to stop work until she gets the corrected card.
Diaz from YouTube has this question. He filed PERM application in October of 2023. Is it time for it to get approved? Yes, we are noticing that in the early part of October of 2023, we are starting some approvals right now, but not all the ones which we filed in October 2023 got approvals. He has a subsequent question that once the PERM is approved, can he file I-140? Along with the I-140, can he file the advanced parole, or does he have to wait for the priority dates to become current and file the 485? At the time of 485, he has to file, or at the time of I-140, can he file an advanced parole? The answer is only at the time of 485 you can file the advanced parole, not at the time of I-140. You'll have to wait for the priority date to become current. Question from Chandra Paritala and a couple of other people with regards to the EB1. Why are the EB1 dates not moving for Indian nationals? The reason is that there are a lot of people who are cutting the lines. That's one of the reasons. There are two reasons why EB1 dates are not moving for Indians. One, there is a lot of demand from other nationals. As you know that there are 40,000 green cards available. Out of them, approximately around 7% can be given to any particular country. And if other country nationals are using the entire things, the Indians will only get 7%, which is approximately $2,800. 2,800 numbers, sorry, I'm moving into dollars. 2,800, that includes the dependents though. Now, if the other countries' nationals don't use up that, then Indian nationals will get the remaining of the 40,000 that are not used by the other nations. Since the demand for the other nations have gone up, that's a reason, one of the reasons EB1 is not moving that fast. The second reason I was pointing out, cutting the lines. What do you mean cutting the lines? That doesn't happen in USA. It only happens in some other countries. No, you may be wrong in this particular scenarios. People who have had EB2 and EB3 approval before, they are able to get either EB1C approved in some cases, or they're having to get EB1A approved in some cases. And then their priority date gets ported from EB3 or EB2 to EB1. So, for example, if somebody's priority date is 2016 and now they go to India, stay there for 1 year, and work at a higher level position and come back to the same company here in the United States, that company can file an EB1C and they can retain the 2016 priority date. That is what I meant by cutting the lines. There are also some people who are going to EB1A. They are publishing articles, they are improving their skill levels and improving, getting patents and whatever is required for EB1A, and applying EB1A, and they're putting the dates to EB2 to EB3. And these are the people that are cutting the lines. That's the reason why we are not seeing a significant improvement in the EB1 for Indian nationals.
Vin K from YouTube says, in 2020, I filed the I-485 under EB3. In 2022, I did a transfer of underlying basis to EB2. And then 2024, I'd submitted a supplement J due to a name change in the company. Now, if I join a new employer, can I select any category? Yes, you have both, assuming you have both EB2 and EB3 I-140 approvals, you can. You may want to wait until one of those priority dates, final action dates, is actually current, and then submit the supplement J in that category as a way to get the attention of USCIS that, hey, my date's current and I have this approval in the EB3 category or whatever it is. So yes, you can switch back and forth as many times as you want.
Sumit Kumar got $50 for a bank referral. On the 1099, does he need to report it? Will there be an immigration problem? Yes, you're supposed to report it to the IRS. I don't see that as a problem if it's a bank referral where you referred a bank and the bank is giving the money to you. I don't see this as a problem, but there are some 1099s, especially when you are working as an independent contractor, that becomes a problem. But there are a lot of 1099s that are not a problem. For example, if you're invested in a corporation and you're not involved in the management of the company, and the company makes a profit, they issue a K-1, and that's fine too. You have invested in the stocks and they have given dividends. You get a 1099, and that is perfectly all right. You bought some stocks, let's say NVIDIA stocks, and now you sold those NVIDIA stocks and you made money, and then they issue a 1099. That's not a problem. So 1099 automatically is not a problem, but it's when you are employed as an independent contractor. Let's say, for example, you're driving an Uber and then you get a 1099. That's a problem because you've been employed, and as an independent contractor, you're working as an Uber driver. That is a problem. But if it's a stock market, bank, certain investments, not a problem at all.
Renjini from Facebook says, I have my stamped visa with company A till October 2025. Now I moved to company B and my H-1B extended till 2027. If I travel to my home country this July, do I need to go for Dropbox? No, you don't. Your old visa with company A that's good until October allows you to still travel up until October, even though you got an H-1B transfer to company B. But when you're coming in at the port of entry, you need to open up your passport to your H-1B visa that's expiring October 2025 and give them your I-797 approval notice that's good till 2027, and check your I-94 online on the CBP website to make sure they give you till 2027. Sometimes they mistakenly only give you till 2025 because that's what's on your visa. Sometimes it's because people don't provide the I-797 approval notice from the new employer. But because you have a valid visa from your old employer, it's still valid. Even though you have a new employer, you can use that visa up until October 2025.
KKP has this question: is it risky for a H-1B transfer for a new company? Is it risky to file a green card for a new company and a small company? You can do one thing, KKP, to avoid the risk. You can wait. You can have them file a premium processing for H-1B. Let them get the H-1B approval for 3 years, and then you can go join them. That's going to be much safer for you. When it comes to the green card, though, we see smaller companies have much better percentage of getting the green card approval than compared to the bigger companies. So there are, because the HR are more available. Their HR is a little bit more flexible, I would say, because let's say, for example, they have to conduct an interview for a candidate, and the HR may be easily available to conduct an interview. But if it's a major company, they may have a lot of process to interview a particular individual. But here, if it's a smaller company, they may interview the eligible candidates. So definitely smaller companies have more advantage in filing a green card than that of the bigger companies. So.
Narasimha says, my H-1B grace period is ending March 15th, so I only have 13 days left. Is that enough time to transfer my H-1 to a new employer? Or is it safe to file a change of status to B2? I mean, technically a transfer could be filed in 13 days because the LCA takes 7 days to be certified. But if you are, if your company is bigger and they're slower, or their law firm is slower to where it might take longer than that, it is still safe to file a change of status to B2 that you can request 180 days. Once you have the receipt notice for that, the company can file a change of status back to H-1B without you having to exit the US or go for stamping.
We Love Dogs from YouTube has this question: can I apply the lottery if STEM OPT approval is still pending? You mean to say the company can apply the H-1B letter? Absolutely, you can. Not a problem whatsoever at all. Ravi has this question: can the H4 go for stamping when the H1 does not have the passport stamped? On the passport, it's not stamped. I'm assuming, Ravi, that the H-1B person is here in USA working. And in that case, if the H-1B person is in USA and working, no problem, the H-4 person can go for stamping. The stamping does not need to be there for the H-1B person to go have the H-4 person go. For example, you may come on L1 and L2, and now you convert to H1 to H4. And can your wife go for H4 stamping? Absolutely. You came on F1 and F2 visa, And now your wife is going to, you are on H-1B, your wife is going for H-4 stamping. Absolutely not a problem.
Suchi says, how do I update my I-94 after moving to adjustment of status pending while staying in the US? Good question. And this is one of those cases where you don't actually use the I-94 anymore if you're in adjustment of status. So if you are staying in the US based on a pending I-485, your proof of status is now your 485 receipt notice, and you don't need to rely on the I-94 anymore from that point.
How is the extension process of H-1Bs going on? This question is coming on. Extensions are relatively okay, but we're noticing a lot more RFEs on the transfer. The next question that is coming is that should we do premium processing for the extension? One thing I'm telling you for everybody, get it resolved before the I-94 expires. Let's say your I-94 is expiring in July of 2025. And now you file an extension and they don't adjudicate the application until August of 2025. And now there is an RFE. What kind of tension you will go through? What will happen to the kids' education? What will happen to your home? What will happen to the car? What will happen to your job when you leave the country? Don't face that problem. Do the premium processing, get it resolved before July. If by any chance the H-1B gets denied before July, what is the options? File it again. You can file it again. So that's the thing. You get 2 shots and sometimes even 3 shots at filing the H-1B application. That's the reason why we strongly recommend get it resolved before your H-1, your working visa expires, not afterwards.
OD 2013 says my H4 and H4 EAD are expiring this August, but my passport is expiring in March. My spouse's H-1B extension was just approved. Should I file the H4 and H4 EAD extension with my current passport, or should I get the new passport first? No need to get the new passport to file the H4 and H4 EAD, but you do need to file the H4 and H4 EAD before your current passport expires. So as long as it's valid on the day you're filing the applications can still be approved. They will be approved beyond March 2025. It's not like how we were talking about your I-94 gets cut short when you travel on an expiring passport. That's not the case when you're filing an extension with USCIS. So just make sure there's no gap between your old passport and your new passport, but you can go ahead and file now.
We have this question from Facebook. It's a little bit more complicated question, though. I think so. I know the answer, but I'll let you answer it. But it's a bit tough. It's a bit. This question comes from Miguel. He has an I-140 approved under EB-1A with company A. And now this company is acquired by company B. Now this is EB-1A, not EB-2, not EB-3. Now we know that in EB-2 and EB-3, we have to file an amendment to file the 485 application. Isn't EB-1A based on this individual capacity, even though the company filed it? Because it's extraordinary of this particular person, not about the company. So does the company needs to file another I-140 for him to file the 485?
I don't think so, because it is the self-petition category, even though the company did file it. I don't think they have to.
In the 485J application, it's clearly mentioned that the 485J is not needed at all for EB-1A. Yeah, it can be interpreted otherwise also, but yeah, we have done some, had no issues, but who knows, there may be issues. But yeah, we both don't think so that you need, but let's see how the immigration is going to say on that at a later date.
10A says, I have a pending 485 with a priority date in 2014. EAD and AP are good till 2030, and I'm also maintaining H-1B status. Is it advisable to move to EAD and give up the H-1B? So there's a couple things we look at. Number one, is your I-140 approved? I'm assuming yes, since your priority date's way back in 2014. And then number two, are there any potential red flags in your 485, any criminal issues, any medical issues, any prior status violations or problems with your immigration status that could cause the 485 to be denied. If all those are no, the chances of having difficulty with your H-1B going forward over the next 4 years versus the 485 and the EAD and AP over the next 485, over the next 4 years, it's probably going to be more difficult to stay on H-1B than it is to use the EAD. Because the H-1B, we are expecting to see new types of RFEs pop up anytime now because the regulation changed in January. We have a new administration. They might change the wage levels. There's all kinds of things that they did in the prior Trump administration that caused people who had been on H-1B for years to end up with a denial. Whereas people who had EADs, the only thing you have to prove to get your EAD renewed is that you have a pending 485. The EAD doesn't have any restrictions. So it's much easier to be on EAD and travel with your AP than H-1B during a Trump administration. Now, the risk is hopefully your priority date would become current before 2030, so you don't have to worry about renewing the EAD AP. But the biggest risk is what happens if your 485 unexpectedly gets denied? You're immediately out of status. You don't have non-immigrant status to fall back on. And it does happen. It's a small number of cases, but there is certainly a risk. I mean, people get denials because they didn't get an RFE in the mail asking for an updated medical. That's probably the most common denial. Sometimes they get denials because of officer at an 485 interview at a local field office who knows nothing about employment-based immigration denies because of something that was said in an interview when everything was proper in the case. So there is risk for sure of the 485 just being randomly denied. But I think the chances of an H-1B denial these days are probably higher than the chances of a 485 denial. So it's definitely something you've got to consider personally. How comfortable do you feel
Sai
with
Madhu
that?
is asking, are the people who are born after February 20th, are they getting citizenship? Yes, according to the court order, they are getting, but we strongly recommend anybody who's getting born after February 20th, don't wait any moment, just get the birth certificate, get the passport as soon as possible. There may be, we don't know, there are arguments made that it may be legal, it may not be legal. Who knows? The Supreme Court will decide whether what Trump did is legal or not. That will be decided. But if you get the passport, though, as compared to not getting the passport, you may be in a greater advantage. Who knows if the Supreme Court decides that if you have applied, you already got it because you're eligible for it, you will get to keep it. And there are certain things where they may not revoke the citizenship, which they have to go to a lengthy process unless Supreme Court allows it. They may have to go to a lengthy process to revoke the citizenship. So definitely at this point of time, we have no problem in getting the birth certificates. We have no problem in getting the citizenship or a passport. That's how you get an easy citizenship, that you getting the passport is the best way. Have no problem. We recommend everybody to get the birth certificate and the passport ASAP.
Dinesh says, my wife is on H4 EAD and has a full-time job, and the employer is willing to file an H-1B. Do you suggest that she moves to H-1, or do you recommend she go for H-4 stamping? I definitely suggest, if the employer is willing, to go ahead and go through the lottery this year to try to switch to H-1. Under the prior Trump administration, they did have plans to eliminate the H-4 EAD. They never went so far as to publish the proposed regulation. It does have to go through the regulatory process. And they have not come out with the regulatory agenda yet for the new Trump administration, but I do expect eliminating the H-4 EAD will be on it again. So there's a high likelihood sometime in the next 4 years that it could go away. So I would definitely recommend going through the lottery every year over the next 4 years to hopefully get switched over to H-1B. If she's wanting to travel and needs an H-4 stamp, as we said at the beginning, don't travel if you need stamping. There are just too many things that could go wrong, and she would end up stuck outside the US.
There is a memo, USCIS memo, which legally there is a memo which pauses all the EADs. So people are fearful if that is going to be applicable to all the EADs, though. This is published in National Law Review at this point of time. It seems officially that most of the lawyers may agree that there is a memo in USCIS which they have not published it, barring the EADs, but that memo, according to what we know about, is only applicable for TPS, a political asylum. TPS is temporary protection status, like for Nepal, for certain categories of Haiti, some Central American countries, Nicaragua, Venezuela, and certain other countries, Cubans, Colombians, some Colombians, it's applicable. And there are a lot of EADs, I would say, including the political asylum, refugee EADs. There are more than a million EADs under that. But in that memo, though, it is very clear that the H4 EAD is not included in there. So that means it won't be barred because they have to go through regulation, as Emily has pointed out. And also the 485 EAD is not included in it, so you don't have to be fearful about. And the DACA EAD is not included in it. So it's mostly about temporary protection status and political asylum. And this is not an official information. At this point of time, it still is unofficial for this temporary protected status people. But yeah, based on what the Trump administration is, he may go after the TPS EADs and political asylum EADs.
Couple questions coming from YouTube about H-1B transfers, extensions, and whether we should do premium processing. How are transfer approvals nowadays? I'm not really seeing a difference yet in H-1B transfers. We see every once in a while a random type of RFE, something that we don't normally see, seems to be officers just not knowing what they're doing. Hate to say that. But generally, transfers are, for now, going smoothly. Extensions are going smoothly. I'm not seeing an increase in RFEs yet. I do still recommend premium processing for H-1B transfers and extensions. It's very important, especially for extensions, that you get the answer before your current H-1B expires. Because if it is a denial, you will have many more options for resolving the issue if your I-94 has not yet expired. So extensions, definitely file early and file it in premium if your employer is willing to do that. Rafi says, do you see in the upcoming H-1B season that approvals might only be given for a few years rather than the usual 3 years? It is possible. With the new regulation, it does seem like they're going back to requiring possible end client letters and contracts and that sort of thing. They're not looking at employer-employee relationship, which was the big deal before. Now they're looking at, is there a bona fide specialty occupation work available? So we haven't seen changes on that yet, but it could be coming because that regulation only took effect a month ago. Like we lost Rahul there. Let's see here. Are we seeing delays in the Vermont Service Center for H4 and H4 EAD filed separately January 16th? I would say, I don't know if you're talking delays in receipt notices or delays in processing. They're definitely being processed slower. We definitely are not getting the H4 and H4 EAD approved with the H-1B like we were before under the Edikuni settlement. So yeah, they are taking longer, probably closer to 8 months when they're filed separately. Himanshu says, I entered on AP and I want to renew my AOS EAD. Which date do I need to consider for 180 days? So EADs can generally be filed up to 180 days before they expire. So it's the EAD card expiration that you're looking at. The I-94, when you come in on AP, your I-94 end date is irrelevant. That's the only time I can say that you don't have to look at the I-94 is when you enter on AP and you have a pending 485. A couple of people had asked about domestic visa stamping. Is that coming? What is the plan? We haven't heard anything since December on it. And obviously we have a new administration. We have a new Secretary of State. So it's very possible that that whole idea is being scrapped. We have not heard that, but I definitely would not expect anything to come of it anytime soon, unfortunately.
When the visa stamping comes in, though, even if it's an administrative processing, why does it say it's been denied?
Yeah, that's a great question. I guess they're thinking, well, we can't approve it right now, and we have to make a decision right now, so we're going to deny it, but we're still processing it. It never makes sense to me, and unfortunately, that means on any future DS-160 that you fill out, you do have to say that you've been refused a visa, even if you later get that visa stamp approved. But yeah, it does not make sense. But a lot of immigration doesn't make common sense. That's definitely one of them.
Have you noticed any, after February 19th, any newborn USA birth certificates? Yes, has been reported, had no issues at this point of time.
Santosh says, my visa is valid till 2027 with my old employer, but I got laid off and have transferred to a new employer. It's approved. Do the dependents need to file for the transfer with the new employer? No, I'm assuming the H4s are also good till 2027, so it's not mandatory for them to file. I usually do, when I'm filing a transfer, I usually do include H4s, even if they're not expiring soon, just so everyone has the same end date, because now you're going to have to remember that your H4s are expiring before your H-1B expires, and so they're going to have to file separately, and it just becomes a bit more of a hassle.
Can I re-enter USA on advanced parole if the H-1B is an administrative processing, or will they question it? The answer is yes, you can, but I would take a caution though, since you're an administrative processing in the H-1B, you may be quizzed more at the port of entry. I would definitely consult a lawyer to get it, make sure everything is okay. I mean, if you have the advance parole, I mean, I don't see any reason whatsoever for you to get the stamping done there, because you can come back and your H-1B is still active. It doesn't become inactive. So let's say, for example, you have an advanced parole until 2028 and you have a H-1B until 2027. You come back into United States advanced parole, you can extend the H-1B, you can transfer the H-1B, you can amend the H-1B. You can do all these things though. So why go for stamping and invite trouble?
Jigar says, my AP renewal was approved while I was outside the country. I came back using my existing AP, which was still valid. Is the renewal valid? Yes, it is. In that case, that's fine because you had a valid AP. Your travel did not impact the pending AP renewal. The times travel does impact a pending AP is when it's the first AP and you travel without having another valid AP, they will automatically deny that AP due to the travel. But in your case, you're fine.
More questions on EB-5. Yes, definitely the Congress may raise the limit from 800,000 to more. Definitely that is in the books, I would say. But will it be 5 million? I don't think so. That's a little bit too much amount to think about. But who knows? Trump administration may fix that amount to put restriction on immigrants coming into the United States. It is the Congress can, but it has to go to the Congress, so it cannot be done by the administration unilaterally.
Butik says if someone gets stuck outside the U.S. for administrative processing for H-1B stamping, is litigation an option? It can be. It depends on how long the administrative processing is taking. But if the delay becomes unreasonable, you can file in federal court under the Administrative Procedures Act due to the unreasonable delay. Sometimes after that filing, the consulate might wake up and decide what they're going to do with the visa. They might approve it. They might ask for more documents. They might deny it, but they might issue a decision on that. Sometimes the government decides that they're going to fight the litigation on jurisdictional grounds, saying that the courts don't have the power to tell the consulate what to do. So that does happen sometimes. It just varies case by case and in the specific
Abhi is saying that
circumstances.
my spouse employer is not updating the I-9 to reflect the EAD automatic extension. Most probably, the Abhi is telling that his spouse employer is telling to terminate the employment because of he does not understand the automatic extension. We can ask a lawyer to write a letter to them that they are safe if the automatic extension is applicable, especially if it's an H4 EAD. The H4 must be I-94 must be extended for the EAD 540 days automatic rule. So if it's not extended, it's not going to be, the 540-day rule is not there. The instructions for the I-9 are clearly there for the in the I-9 form itself, where the instructions for the I-9 form on the USCIS website, it's there. I mean, they can look into that thing, and based on that, they can put they're safe if they do that. So I don't know why they are hesitating if your spouse has the 540-day rule. Anything, Emily?
Nope, I think we are out of time for today. Thanks everyone for joining us. As usual, we'll be back next Tuesday at 5 o'clock Central Time. And in the meantime, you can sign up for our free newsletter by going to rnlawgroup.com to get updated whenever we post any new articles on our website. And don't forget to check out our podcast called Visa Vibes. It's available on Spotify, Apple Podcasts, and also on YouTube.